you, Mr President. The Greens will be supporting this legislation, which provides a regulatory framework for wind farms to be developed in the pastoral areas of South Australia. It is very clear to us that the energy mix of the future will include a far greater proportion of renewable energy, and in fact we need to be aspiring in this state and in this country to moving to 100% renewable energy. And whatever the mix of renewable sources, it is clear to us that wind energy will be a big part of that mix. So this bill is welcome. The federal Liberal government currently has the renewable energy target under review, although I think it's probably more accurate to say they have it under attack. And I think it's very clear to renewable energy companies in South Australia and elsewhere that if that target is watered down or worse still abolished, then the prospect of new wind farms in South Australia is quite bleak. So we do in this state need to understand that what's happening in Canberra has a big impact on the future economic development of our state, because as we all know, South Australia is the heartland of wind energy in Australia. I mainly in this contribution want to put on the record a number of questions for the Minister to answer when the second reading debate is concluded. And the first question I have is whether there is a particular part of the pastoral lands that has already been targeted by wind companies for development. It seems to me that legislation like this rarely comes out of thin air. My expectation is that there has been some discussion. I'm interested to know where those areas might be. My understanding of the wind energy is that there are two main factors that they're looking at, and they're the two W's, wind and wires. Is it windy, and are there wires to take the power to market? Most of the outback areas under the Pastoral Land Management and Conservation Act don't have great access to the grid. Some areas are better than others, but certainly we know that many parts of the outback are windy. So I'm curious to know which areas the government believes might be early cabs off the rank when it comes to wind farms on pastoral land. The one aspect of the bill that gives the Greens the most concern is the effective right of veto held by the mining industry. Now, members might look at the bill and say, well, there's no real right of veto, because if a mining tenement holder objects to a wind farm, then there has to be a court process, mediation first and decision later. But my question of the government is, what other area of industrial development in South Australia subjects developers to mining company rights of veto? I can't think of any other area where a developer is obliged to go to perhaps an overseas speculative investor who has acquired access to a few hundred square kilometres of South Australia for the purposes of exploration, and that company can effectively put a halt to a wind farm development. I don't understand why that's required. I think it's unfair and it's unreasonable, and as has been mentioned before, it's certainly not paralleled in any rights attached to the pastoral leaseholders themselves. For example, the person who's living on the land and who's grazing cattle or sheep pursuant to their pastoral licence, they don't have any power of veto, yet a mining company with purely exploration rights is able to effectively stop the wind farm going ahead. And just to put this in perspective, if members are keen to have a look at the map of mining tenements in South Australia, you will find that if it's not 100%, it's well into the 90s. The percentage of pastoral lands that are covered by mineral exploration licences or mining leases, or also exploration licences under the Petroleum and Geothermal Act. We're talking the whole of the pastoral lands in effect. So I'd like the Minister to answer the question, why do we have this unique situation where these companies effectively are given a veto over also note that in relation to access agreements, and access agreement is the label in this bill that is given to the type of agreement that has to be given by the prescribed interested parties before the Minister can proceed to issue a wind farm licence. These prescribed interested parties include the lessee, the holders of mining tenements, and also various native title holders or potential native title holders. But of those four groups of prescribed interested parties, it's only the holders of resource tenements who have to negotiate the access agreement, which is also quite odd because when it comes to access, most of the tracks and the roads and things would probably be under the control and management of the pastoral lessee rather than mining companies. Anyway, that's the bill as it is. If there is a disagreement, if the mining companies won't sign an access agreement with the wind farm operator, then it goes off to the Environment Resources and Development Court. And it seems that when such a dispute reaches court, there's first of all a mediation process. That makes sense. Always good to mediate a dispute if that's possible. If it's not possible, then it goes to a decision. The only thing that gives me some comfort in the way this mining veto regime has been developed is that I would presume that the Environment Resources and Development Court, in considering whether or not a mining company has a valid reason for refusing to sign an access agreement, would be obliged to take into account the objects of the Act. The object of the Pastoral Land Management and Conservation Act now include, pursuant to this bill, under the proposed new Section 4, Paragraph F, to provide for the operation of wind farms on pastoral land concurrently with the land being used for pastoral purposes. There is no object of the Pastoral Act to promote mining. So I would hope that if a dispute did reach the ERD court, and if the dispute was, if one of the protagonists in the dispute was a company that merely had an exploration licence, then the court would determine that their refusal to sign an access agreement was unreasonable. It'd be different, of course, if it was a mining lease and someone wanted to put turbines in the middle of the works. Well, clearly that's not compatible. But I would hope that the court would be very low to stand in the way of wind farm developments if the only objector is a mineral exploration company. The third issue that I want to raise is in relation to the rehabilitation of land afterwards. And this is an issue that was raised in evidence to the Select Committee on Wind Farms, which I imagine Standing Orders precludes us talking about because I'm not sure that it ever reported, but in any event, it was an issue raised by witnesses, and that was that the wind turbines may have a life of 20 years, 30 years, potentially up to 50 years. The answer is we don't really know because the industry is too young to know how long these things last. But what I find interesting in this legislation is that the Minister must include in a wind farm licence conditions ensuring that a proper process is put in place for the eventual decommissioning of the wind farm and rehabilitation of the wind farm site. And I make the point that a provision such as that does not apply to any other wind farm in South Australia. There is no publicly enforceable legal obligation to remove a wind farm and associated infrastructure once it has ceased operation. Now, members might think that those rules exist in the contracts between farmers, freehold farmers and the wind farm operators. And that's probably right. I would imagine that most of the contracts between farmers and wind farm operators would have a clause in there saying at the conclusion of operations, the wind farm developer will remove the turbines. I also imagine that in 20 or 30 years' time, the wind farm operator, faced with $1 million bill for removing turbines, is likely to go back to the farmer and say, why don't we split the difference? We'll give you $500,000 if they can stay. And I'm sure that the farmer would probably agree that having a few very large statues on the property is a small price to pay for what the wind farm operator would pay them to not have to remove the turbines. But it seems that isn't the case here. The Minister is legally obliged to include some sort of a clause which talks about the decommissioning and rehabilitation of the wind farm site. So my first question is why? And I'm sure the answer is probably, well, this is public land rather than private land. But it also seems that it could require the rehabilitation of tens or 100 kilometres of power lines as well. And again, that's not an obligation that has ever been imposed on any other energy utility, to my knowledge. So I'd like if the Minister could explain that. But all in all, I think that this legislation is a good move forward. If the reason that prospective wind farm areas haven't been developed is simply the land tenure and the legislation, and this legislation fixes that, then that's a good thing. But I do look forward to